Okay. A more simple procedure will basically a more simpler procedure is to be followed if you have a will. If you have a will, the executor appointed in the will must apply to the High Court to apply for probate and sijil faraid. Okay. Normally only one application at the High Court, then after that the court will grant the probate, right? Once the probate is granted, the assets will be free. So from here you can see the application for letters of administration when there is no will is longer than when there is a will, whereby the procedure is shorter. Okay, generally speaking, the procedure to apply for probate and letters of administration, the time taken to apply for probate and administration is different. In intestacy, whereby when you leave a will, an executor is appointed in the will, so the executor is responsible to apply for probate, and normally the time taken to obtain probate will be roughly around 2 months to 18 months from the time the probate is obtained until distribution. But in actual fact, the distribution varies from case to case, because if an example, the assets of the estate consists only movable property, of course the distribution will be faster, because once we obtain the probate, we can get the assets from the respective institution, and upon a settlement of all debts, we can make distribution. But if there is immovables, generally the process of distribution will be longer. In intestacy cases whereby there is no will, as seen in the earlier slide, you can see that the process will take longer, because normally the family members will take longer time to decide who should be appointed as the administrator. And in some circumstances, the family members cannot agree on the appointment of an administrator, and that will take a longer time. So that's why in this slide you can see the application for letters of administration will take a longer time. It may take 1 year, it may be longer. And after, assuming the family members can agree on the appointment of an administrator, there is another court application that has to be made to the court to basically apply for to apply for dispensation of sureties if the administrator is unable to provide a guarantor. If you look at the earlier slide, which basically says that the 2 sureties has to be provided.